Done.
Get going. We'll update Bob as we need to when he joins us.
Hey, Jim.
Okay. Yes.
Jim, just real quick. I've got a hard stop at 3 o'clock. I've got another meeting I've got to attend. So just FYI.
Okay, that's good. Okay, let's call your meeting to order. So about 1:12, 1:11, 1:12. First item on the agenda is the approval of the agenda. Are there any, it's up on the screen now. Are any comments, additions, things that people don't think believe belong there, deletions and so forth? Okay, if there aren't any, we'll consider it approved, and we'll go on to the minutes. The minutes of the December meeting have been distributed. Any corrections, additions, comments, and so forth? I think these minutes may be among the shorter minutes for whatever reason, I'm not sure. Okay, we'll consider them approved. Any public comments? I don't see anybody other than those of us on the committee and Josh as well. We don't have any. I don't see either Greg Ellison or Tom Stoss, who joined us last time. So we'll consider that there are no public comments, and let's continue on to the agenda. Continue on to the unfinished business. I'm sorry. The first item on the agenda under unfinished business is the status and proposals documents dated 12/13. That's the two documents that I distributed separately earlier in the week. The one is that status Excel spreadsheet, which has been updated to the date, whatever it was. I think it says 12/13. The other is what is now titled the proposals, bylaws proposals document. The only reason that's on the agenda at this point is not to discuss the content, does everybody understand my attempt to trying to explain those two documents? The one that's up there now, the status, is just the continuation of the status format that we've been using the last couple of 3 meetings. The one difference is I dropped the color coding out of there. It was getting kind of cumbersome. But at any rate, that reflects our status as of the 13th, and there's not any real significant change in the status since then. The other document, we had previously referred to a September 17th document. What that was the status of our work at that date that went forward to the work group for its review. And the work group went through that review and effectively turned it back to ourselves, and we're on our own to do our work on the proposals basically as we see fit. That's my best way of expressing how it came back from the work group. What you have now in what I've retitled bylaws proposals is each proposal as it stands as of that date. Now, there's some have our drafts there that we prepared here recently, and in a couple, 3 cases, there is no status to report. But this document will be updated as things change on those proposals, and that this will be the document that when this is all over and done with, whether it's piecemeal submittals or the whole thing at once, this document will include our final action on proposals. Right now, it just shows stuff that's primarily in process, except for that individual first one, that the eligible to vote topic. I believe we've completed our consideration pending a real final review. So the only thing I'm bringing up right now is, do we have any questions about these documents and what they're intended to do? I'm not intended to start on review of the status of the proposal. That comes later in the agenda. Okay, let's keep going here. The next item on the agenda is the search committee. Let me start scattering my papers so I get completely confused. I believe I sent a message around summarizing what took place at the board meeting last Saturday. The search committee was on the agenda for its discussion. And the board discussed it for some period, 15, 20 minutes. It can be seen on the YouTube video. What came out of that meeting was to continue retaining the search committee. We're going to drop any ideas about deleting the search committee and finding some other way to addressing how we find candidates for the committee, or how candidates, I'm not the committee, but the board, how candidates for the board make their applications and so forth. We're going to continue on with a search committee. That's number one. Number two, a primary, if not the primary consideration for us, is to go to a standing committee as opposed to a committee which the bylaws call for an appointment every year. As of or before February 1st, the committee is supposed to be appointed in the bylaws provisions. To go away from that to a standing committee without further definition of what's meant by standing committee. Now, excuse me, here's my suggestion for what we do. I have not prepared any specific discussion for how to go forward. I'm just going to make some suggestions as to what we do today and how we proceed with this particular item. My suggestion is that we each take a look at the provisions that are in the bylaws. We each consider that the guidance is basically twofold. One, we're going to keep the committee. It's going to stay in the bylaws. And two, a primary objective should be to, in some manner, establish the committee as a standing committee so that we do not have this concern of being able to get another committee together every February. Those are the two basic things that came, or primary, if not the only things that came out of the discussion item. So each of us, I consider in particular the committee, how we handle the committee, how we express the committee in the bylaws, and we can exchange information about this topic, search committee topic, offline. We're not going to talk about decisions. We would be exchanging information to the extent that each of us feel like we can or will do so before our next meeting, so that we can have this topic on the agenda for the next meeting and have discussion items in hand, rather than proceed just on a cold basis like what we would be today on the search committee topic. There are a couple of other things that I wanted to mention on that. With regard to the committee and what we say about the committee in the bylaws, there are a couple of different ways. One, the committee structure is already expressed in the bylaws. It's just not been a very satisfactory way of doing it. And another standing committee, the ARC committee, its committee structure and membership in particular is identified in the declarations of restrictions. However, the terms and so forth are set in accordance with the C01 general committee document, as well as a document for the ARC committee itself. On the other hand, the elections committee is simply referred to in the bylaws. It's a standing committee. It's a governing documents committee. It's simply referred to in the bylaws as having been, or to be appointed in accordance with it refers to a specific section in Article 10, Section 10.02, which basically says the board establishes committee criteria. So how we go about establishing the search committee is, those are the two considerations, or two ways to consider it. One, same as the elections committee, or in more detail in the bylaws themselves. And I'm not trying to point either direction. There are other provisions in the bylaws relevant to the search committee to consider. One is that the applications go to the search committee and it sends a list of applications. I don't know if it really says sends the applications, but really the application should go to the secretary by the 15th. That provision, not necessarily the 15th provision, but the 10th cutoff date, and then a 15th date to the secretary should be open for review. The gathering of information by the search committee should be considered in our search committee consideration of the bylaws. There's another, the search committee report called for in resolution M09, made a recommendation to delete the two candidates provision. Maybe that should be deleted from an objective of the search committee, but I don't know that it should be deleted from the bylaws as a board action item, as it is covered next further on in section 5. But again, those are items I think that we can be considering, or should be considering, that we can put together our own thinking, exchanges as we may feel comfortable, but be prepared in our next meeting to go forward with a more detailed consideration of the search committee proposal. Okay, I've gone on much longer than I really wanted to on this. I want to open it up now to what other ideas, suggestions that we may have.
Well, frankly, I found the recommendation, I think the search committee itself recommended it should cease to exist.
Yeah, I did.
Which I thought was sort of interesting, but I guess I'm a little curious, and maybe Colette can answer this best, but the board clearly wants a search committee. I mean, the search committee itself says they shouldn't exist, but the board is saying, no, we got to have one.
Yeah, I can address that. I think the board's position is that the problem with the search committee is the fact that it's not a standing committee. And so when you pull together a committee a month before or a couple of months every year before the election, that kind of leaves that committee a little bit flat-footed. And so our thought is that if it's a standing committee, we could give them broader authority other than just the receipt of candidate applications or registration forms, but give them functions such as, which they've done apparently in the past, pulling together candidates and informing them about the candidate process, even outreach to prospective candidates to educate them about the association, the duties of the board, so on and so forth. And, I think that I, for one, and I think others on the board, believe that with social media and electronic communications, there are a lot of different ways to engage in outreach to the public to encourage participation and encourage education. We have I don't know if any of you have looked at the Ocean Pines Residence Academy. That's a really top-notch video that explains the association from top to bottom, including the governance. And so the academy was originally conceived under Bob Thompson's management of the association as a way to educate new residents in the community and encourage volunteerism on our committees and on the board of directors. And so the board, I think several of us feel that there are these mechanisms in place to try to generate greater interest in becoming involved. The survey, the homeowner survey, there were 517 people out of the 1,600 plus who completed that survey, who said that they are interested in more volunteer opportunities. Clearly, there are people who maybe are not informed of the various volunteer opportunities that are available. So the idea here is to kind of expand the actions that the search committee engages in service of soliciting volunteers for service on the board.
Well, that's fine. I mean, again, I'm just going by the search committee status, the document that's in front of us. But it's, again, just to me, the communications advisory committee is willing to take on almost everything you just described.
Well, but they're not. I mean, they say, yes, we will do communications stuff, but they don't want to do search stuff. They don't feel that they can replace the search committee. And so I think they would work very well in concert with the search committee on communications issues, but they don't want to take that on.
Well,
None of the other committees was willing to step up and say, we'll do it.
I understand the discrete function of searching for candidates to run for the board. I understand what that is, but just going by your description of what else the board thinks could be done, it sounds to me like everything is consistent with what the communications committee does. But look, if the board wants the search committee to exist, I mean, that's what happens. I mean, I understand what both you and Jim are saying. I guess my question is, you could probably try to put something together, but it does seem to some degree, once you say, okay, they're a standing committee, and you go to describe what their function should be, other than trying to find candidates when there's not enough candidates to begin with, you're tromping on somebody else's turf already. But that's above my pay grade. That's fine.
Okay, let me add a comment or two there. First of all, I see Bob's joined us. Welcome back. Welcome.
Finally.
Okay, I don't think you've missed anything particularly important. We've just gone through the preliminaries of the meeting. There has been periods of time that the search committee first appears in the 2008 approved bylaws. Before that, it was a nominating committee, which never really, apparently, at least in later years, did not actually perform a nomination function. There has been, over the time since the creation of the committee, something of a helter-skelter appointment. There were years where it was an afterthought at most being put together. There was a year or so in which, in addition to the pandemic period, that it may not even been appointed. I can't say that for certain without going back through records. I'm not going to take the time to do so. But there's been too much of a helter-skelter, almost afterthought approach to putting the committee in place and operating. If you go back through some of the years in which the committee was formed in an orderly manner, and you read the after action reports that were put out, they are in detail as to what the committee did, the contacts they made to look for people who would be candidates. It was there were instances in which the committee really put forth the effort. And a major impediment to that, and I agree with this, major impediment to that has been the sometimes helter-skelter approach to getting a committee in place. Now, excuse me, yeah, if we get a standing committee put in place and other changes that may help streamline the pre-candidate process or candidate application process, and it doesn't work, well, then we got another situation. I agree. But anyway, that's just some additional comments. I think I've made much the same comments before, and that's probably enough.
Yeah, Jim, and if I would just add the comment, actually, that I made last night at the executive council meeting, what our advisory committees accomplish, and you've been attending these meetings for how many years? 8 years, I think, or more, Jim.
Well,
I think you probably noticed what I noticed last night is that right now we have chairs of those committees that have generated incredible excitement and great ideas for fulfilling the charge of their committees. And I would say this is the first time in the 5 years that I've been attending those meetings that, we've had such a huge number of committees that are just really very active and very functional. And I think with any of our committees, what they do with their charge really has a lot to do with the leadership and the composition of the committee itself. And so I think putting the committee together in a helter-skelter fashion, predicts that we would perhaps be less likely to get people who are going to really take the bull by the horns and, put a lot of energy and creativity into what they do. That's the other thought behind having a standing committee, is that you identify some people who are really interested in working on this and want to work on it over time.
Okay. Again, my suggestion is that we all give consideration to the search committee proposals or proposal, what should be in it, and to whatever extent we have organized thoughts, exchange them, and for sure be prepared to discuss it in detail on our next meeting. Any further suggestions, comments on that? Because if not, we'll keep moving here on our next item. Okay, let's go on to the next item. The way it reads there is expansion of board candidate criteria charging document. What that means is the charging document that discusses the expansion of board candidate criteria. We have two kind of inputs to that, if I can put it that way. One is the charging document itself, and then there's this late entry, but there's this entry of the Frank Daly proposal, which has been distributed, as well as I have distributed where there has been comments to Frank. I've distributed those comments as well. Let's keep those two separate, but as we need to continue through each. And at this point, Keith has done some background work and distributed background work on this topic in the last couple of weeks or so. And I've asked him if he would take this item on here and lead us in the discussion of this item. And if Keith, if you would take it from there.
Roger, thanks, Jim. Josh, can you bring up the HOA resource document?
Yes.
So as he's bringing that up, just to back up, so a couple of committee meetings ago, when the issue of determining owner of record first came to us as something to think about, we talked about it very briefly, and then Jim made a comment that he felt like this was a larger issue than simply the owner of record issue, that there was more to it than that, or potentially more to it than that. It could be more complicated. And so after that meeting, I got to thinking about it, and I was curious what other HOAs and other states have as requirements for their board candidates. And I was almost shocked at some of the really sensible things that a lot of other HOAs and even some at the state level do that we don't address at all in our bylaws. And so this document represents the ones that I consistently found across multiple organizations. And these are links to a lot of those different documents if anybody's curious, wants to look at that. But Josh, if you could go ahead and scroll down to the text. So the first issue related to owner of record. It was curious to me that what I found in a lot of other organizations is that although there's a requirement that you have to be an owner of record, because that's your ticket into the HOA, right? You've got to be a property owner. It didn't have the level of emphasis put on it that I was kind of expecting, relative to our current situation. And what they put emphasis on more is living in the community, residency in the community. And one of the documents specifically, I think it was a state document, explained about how if you own property in the community, but you don't live here, you could be considered an investor. And an investor is going to have a different context within which to make decisions than a resident who lives in Ocean Pines. Somebody who lives here full time, their context is going to be their street, their community, their quality of life, what affects them day to day. Whereas an investor may have a context where they're trying to maximize their return on investment, even if it's eventually a retirement property that they plan someday to move into. Until that time comes, it's an investment. And so the motivations for those two different groups of people could be different. And if you had to choose between which one you would prefer to have on a board as a board member, all of these documents that I reviewed that brought it up preferred to prioritize residency over ownership. So what this does is, if you accept that you have to be an owner of record, but you also accept that it really doesn't matter how much of an owner of record. In other words, do you own the property outright, or are you a 1/10 owner as part of an LLC or trust? That part really doesn't matter under this concept. As long as you can show proof that you are legally an owner of record, either in whole or in part, that box gets checked. Then the next box is, do you live in Ocean Pines? Now, before I go on, I'll just address this briefly, and we can talk more about it later. I know I put in this document here 3 years. And I think Doug Parks questioned it in one of his feedback. Why 3 years? Where did that come from? How does that have any value? And I just wanted to share my thinking on that real quick. So if anybody has paid attention to the social media, there's 2 or 3 different sources of social media related to Ocean Pines. And if you read those social media or track them on a kind of a daily basis, there's a lot of negative stuff in there. And I'm not, some of that negative stuff in there, to me, this is my opinion, is stuff that's never going to go away, because certain people, when they post, it's what they post about. They're just negative. They're looking for the negative. Because as we saw from the survey, a huge percentage of the residents in Ocean Pines are happy with the way things are. But the happy crowd typically doesn't post on social media. It's the crowd who's upset about something. They want their voice heard. They're trying to speak out, right? So if you just moved to Ocean Pines and you haven't lived here long enough to get your own exposure, your own experience, to develop your own opinions, and the only exposure that you had was to the social media posts, it potentially would guide your thinking to think that we're just a soup sandwich, right? Because you wouldn't have your own experience to, within which to understand that context. So what I'm thinking is that a candidate for the board should have lived here full time for a certain period of time. Maybe it's not 3 years, maybe it's 2 years. I don't know. Maybe you can argue it's 1 year. I'm not sure. It seems to me it should be for some period of time wherein that individual has had an opportunity to develop their own opinion about how things operate here in the Pines. It would probably have to be at least a year so that you get through a full on-season and off-season, rotation to see how the whole thing works. But anyway, that's where that kind of came from in order to address a little bit what Doug was talking about. Another thing that was very common in all these documents was not having spouses of the same property serving on the board at the same time. I don't know the legal implications of that. It seems that it kind of makes sense, but I don't know. That was a common theme. Another common theme was co-owners in general. So even if you weren't spouses, having co-owners of the same property serving on the board at the same time. That would particularly be something of concern if if those people were investors and were not residents, right? So now you got 2 votes on the board from investors versus residents. Another common theme was convicted felons. Now, what I saw was the board candidate is not a convicted felon. And one of the emails floating around, I don't remember who it was from, somebody was making some suggestions toward this effort. And they, I think, unless I misread it, said that, felonies of family members or such. I don't think that's a road anybody would want to go down. I don't think that's something would stand up in court. I don't think it's necessary. But it seems reasonable to consider whether or not the board candidate themselves has a felony record. Someone in current litigation with the community. So again, I don't think it would stand up in court if you tried to exclude someone who had previously been in litigation with the community. But if you had someone with a current court case going on, I think that's pretty sensible. You wouldn't want them to be coming onto the board. You wouldn't know what the outcome of that would be.
Well, the other issue with that is if you're, one of your fiduciary duties as a director is duty of loyalty to the association. How can you be loyal to the association if you're suing the association?
No, I understand that concept. But what I think is, and I'm not a lawyer, don't play one on TV, but I've watched it on TV, and I think that argument wouldn't stand up in court.
No, I agree with you that the current litigation is the issue, not previous litigation. If you are currently suing the board, you can, by definition, you're not loyal to the board. So you should not be able to sit on the board.
Yep, I agree with that. Another concept that was in some of the documents was long-term renters. So again, if you're going to put priority on residency, meaning you want to take advantage of the membership who live here full time and lived here for a long time, they potentially have something very valuable to contribute to our democracy, in the Pines, right? So that was an option. We do have a provision in the bylaws currently for a proxy vote. We talked about that very, very briefly. It would have to be broadened some in order to allow that, but it was a consideration. And then the last one that I really liked, scroll down, Josh, was I really liked this one where if you become a candidate, then you have to agree to either, and in our case, we have the Ocean Pines Academy. I think that was, correct me if I'm wrong, Colette, but I think that was the reason it was started initially, was to help new board members get up to speed quicker. But in a couple of documents that I read out there, a candidate for board has to agree that if they're successfully voted in, that they'll either complete some sort of indoctrination course, some sort of training course that brings them up to speed on the association, the bylaws, the directives, etc., or sign a letter stating that you read all these things, you understand them, you're up to speed, and you're willing to abide by them. Which I really like that idea that, I mean, we've got a lot. You know, Jim here is just a treasure chest of information because he's been doing it for so long. But, you know, even with the time I've spent on the board, I couldn't bring forth some of the inherent knowledge that's available there. So I really like that one as well. So anyway, this was just digging that I did because I was curious about what other communities and in some cases state law requires of board candidates for HOAs. And I thought it was interesting, and that's why I gathered it up and distributed it. Over to you, Jim.
Okay. How to proceed with this is the question. Josh, why don't you go back up to the top of the text itself? Okay, that's good. Let's see what each of us is, to whatever extent we may be ready to comment on this, has to say or think about these. I've read through them, of course. I went through each of the websites that are above this in the item from Keith. Living in the property, community, vice just ownership. That presents a problem in our governing documents. There would really have to be some major changes, starting with the declarations of restrictions, and that in and of itself is a daunting task, I believe. As a practical matter, in my opinion, we would have difficulty with altering what we have there now. Now, I'm not at all going to comment on this, but the result of the current litigation may have some impact on this topic. Let me just phrase it at that and stay away from it entirely. But right now, as our governing documents, in particular the Declaration of Restrictions, I think you're going to have, we would have a revision of governing documents issue in order to change what we have now to some form of having to live in the community. And that would go further on down into this, how many years or what length of time you have to live here. Now, on that part in particular, I have always personally, where we have the provision in the currently bylaws provision regarding owner of record since January 1st of the calendar year of the election. What that really means, if you consider the further on down in the bylaws, that means that the owner of record since January 1st would mean someone who has been an owner of record, not lived here, but an owner of record for some 4.5 months to May 15th is eligible to be a member of the board. I've always considered that to be a very minimal consideration. Now that doesn't go to living in the community. That goes just to simple ownership. But revising the bylaws to change the length of time in which you qualify from the May 15th of the year to the May 1st of the calendar year, that can be done. I say it can be done. It should be able to be done. How much you would change, that's another thing. But living in the community versus ownership, as a practical matter, that's going to be hard to confront or revise, if I can put it that way. Anyway.
Jim,
Go ahead, sorry.
I was just going to say, on a personal note, Changing that would have disqualified me as a candidate. I was a part-time resident at the time, had owned property for several years, but part-time resident at the time that I ran. And at the time that I ran, of the 4 candidates running, I was identified by the voters as one of the 2 that they wanted to serve. I also am a poster child for the completing some kind of a training course, because knowing that I had not been a full-time resident, knowing there was a lot that I did not know when I decided to run for the board, I created my own residence academy, if you will, to educate myself, to prepare myself with knowledge of the governing documents, finances, some of the history that would probably, pretty much covers what's in the Residence Academy. So I think that combination, I'm not going to say I'm the best director that we've had, but I would say I've been successful enough that I was reelected. So I think that there are a lot of avenues to get to the point of being prepared to serve well. And I like the ideas that you've brought forth. I think a lot of these ideas are very sound, but I think from my perspective, it is, what you put into preparing yourself to be a successful director that determines your readiness much more than how long you've owned property or how long you've been a full-time resident or, some of these other characteristics that don't guarantee knowledge.
Any other comments?
Yeah, I was going to ask Jim if you could just expand a little bit on the declaration of restrictions and why. So what is the process for getting the declaration of restrictions modified? What would be the issue?
Okay, in this, let me take a little bit of a risk here and get more detail I'm really comfortable with. The declaration of restrictions define how you become a member of the association. And if you go to the bylaws, being a candidate and being a member of the board is expressed in terms of being a member. And it's kind of a side comment. We've had this owner of record. Well, what's owner of record? I mean, well, quite frankly, owner of record should be replaced by the word member in the bylaws, but that's a separate subject entirely. But you're being a candidate and being a member of the board is based on being a member of the association. And the member of this, being a member of the association is defined in the governing, in the Declaration of Restrictions. And again, I really don't want to go very deeply into that. It gets into elements of the litigation, and I'm just not comfortable potentially expressing my personal opinion. Let's put it that way.
Well, what I meant was, is the Declaration of Restrictions something that we can change as a community via referendum, or is it a county or state document that requires a different process?
It's a wholly an association action. However, there are 2 separate categories of sections or declarations of restrictions, a declaration for each section of the association. Let me make that's clear. The first, however, number of it is 12, 13, 14 sections. Those from the initial 1968 sections through about 1995 each have provisions in their declarations that they are amendable by the members in the section. And what it requires is a 50% +1. And when I say 50% +1, I mean +1 additional vote not 1%. A majority of the people who are owners within the section must agree to whatever the proposal is to amend the declaration. The remaining sections, it's basically those that have been created since 1995. It's something like section 15B on higher in numbers. The vote to amend the declaration of restriction for those sections is an overall association vote in which 50% plus one, or the majority of the votes within the association, must approve the proposal to amend the declaration. So you've got 2/3, 3/4 of the sections. Each section controls its own destiny with regard to amending their declaration of restrictions. The other 1/3, 25%, whatever the number is, sections in the association, and they're basically those post 1995 and later, as far as being created, their declarations, amendment to their declarations depends on the vote across the board in the association. Now, for example, I live in section 16. That's our declarations dated somewhere around 2000, maybe 1999. We're in that category that we don't control our destiny when it comes to a change to our declaration of restrictions. We could 100%. There's 503 voting units in the Park Association. We go 100% against it, and the association goes 50% plus one for it. We get it. Same as everybody, or same as anybody else in that category. But that's how the declarations of restrictions are amended. There's one kind of irrelevant, but side comment that will have to be considered in any amendment of declarations of restrictions, at least those that go section by section. It's based on written approval. So that there has to be an accommodation of, you have to figure out how do you get a written vote, if I can put it that way, that can be in some manner recorded in the land records. The declarations of restrictions are recorded in the land records, and an amendment, of course, has to be recorded in the land records. If anybody's interested beyond what I'm trying to say, go into the board of directors page of the website and drop down until we are able to get into declarations of restrictions, and open up any of the declaration of restrictions up through, say, section 15. Pick out 8 or 9, or maybe many of you may live in one of the lower numbered sections. And if you scroll to the back of the declaration of restrictions, you'll get into when there was a 1990 referendum across all of those more or less original sections, and you can see how it was handled there, how the revision to those declarations was handled. It was, I don't want to try to get into any more detail. Again, the primary thing is it's a section by section vote, and vote in parentheses, section by section decision, and then there's a group of sections at the end, more recent sections, in which it's an association vote, not or approval, not the section by section.
So just to be clear, the declaration of restrictions specify what a member is, but the declaration of restrictions does not specify what the requirements to be a board candidate are. Is that correct?
That's correct. That's a good summary. I think you pretty well summarized in a short sentence what I take a long time to kind of try to discuss.
So our bylaws are what provide the requirements to be a board member. So adding some of these considerations into our bylaws to be eligible to be a board member adding the consideration of some level of residency would not be taking away from the membership concept. It would just be adding to it. So it seems to me like if we did want to move forward or recommend something like that, that we should be able to do that without changing the declarations of restrictions.
I think that's correct. Now, whether it's meets a reasonable test to accomplish a desirable end, maybe a different question. But as far as the governing documents, I don't think that would be an inhibitor to what we're talking about.
Yeah, to Colette's point, I don't know what the appropriate line would be to draw there on residency. I mean, I think there's probably a good argument to be made that part-time residents are have something valuable to bring to the table. Maybe there's challenges there because then you'd have to say, well, a part-time resident who spent at least X number of days, in the Pines, and then you'd have to figure out some way to prove that. I think that would all become a rabbit hole that would end up with a lot of work. I'm not sure, but I personally like the idea of putting some level of emphasis on residency. I think Colette's a great candidate. I voted for her both times, but I don't think that that necessarily is always the case with candidates. So I just, my personal opinion is I think there's some value in considering that. Over.
Do we have I can see both sides of the residency issue because obviously I joke I've moved up from part-time to 3/4 time resident, not quite ready to call Ocean Pines full-time yet. We're getting there. But maybe to balance that, or in addition, I don't know which would be better, but what about a requirement of having to show your, like as a part-timer, I can be on this committee, right? So why can't we, or wouldn't there be a benefit to say a candidate should have served at least on one committee prior to running for a board position? I mean, and I'll be honest, my experience in the PTA land is, we're all struggling to find leadership, right? In all of these volunteer positions that don't make money or anything like that. So when you have somebody who's willing to step up into it, but they've had no experience, they've not come to any PTA meetings on a regular basis, they haven't even volunteered on committees, they're not going to be the best leader in that role, right? So same thing could apply for here, is that if we don't show that we've had some experience or a way to show that we are involved in our community, whether we live full-time or part-time, I think is a consideration we should take too, to help make sure that the candidate there, and I agree with Colette in the fact that, it is a personality thing. Some people put more effort into their jobs than others, or if they want to do their job well and not just, give, just like to say that, oh, we added being a board director to my resume when I'm doing other stuff. You know what I mean? So maybe a way to balance out a part-time person would be to say, have you served on any of the association committees to show that you are invested, that you are paying attention to the goings on around here. That might be a way to balance it a little bit and not totally exclude any future part-timers who would consider about running, who may think, well, you know what, I'm soon going to be full-time, or maybe that's the push they needed to become full-time, is that they got elected and they realized it would be easier to do from that point of position of being available in person and stuff. So just my thought on that.
Yeah, and if I could just comment on that, we have 11 committees, and the maximum membership on those committees, I think, is in the range of 8 to 9. And almost all the committees are fully staffed. And so there is less opportunity for committee involvement depending upon those vacancies. The other thing that has changed since COVID is that more of the committees are having virtual meetings, which makes it possible for part-timers to participate in the meetings. It was very difficult for part-timers to be on committees when the meetings were down here, they were in person, they were during the day, or even in the evening. So, I think there are challenges with that criterion as well.
If I may, I feel like I'm pushing a heavy boulder up the hill, because not only have I only lived in the Pines for a little bit over a year, I may not have played an attorney on television, but I am an attorney. So, but having said that, I think I mentioned when we first got this list from Keith a couple of meetings ago that this is really good work. I mean, I buy almost everything in here. I think you can nibble around the edges on long-term renters. I think the litigation question is somewhat problematic, although I do understand the point that Colette is making. I definitely agree with the notion of, some sort of certification in number 8 is wholly worthwhile. Let me, if I can, touch what really seems to be the crux of the matter, which is the number 1 point about living in the community. First of all, I think Keith's initial description as to a division between a business entity owning the property and an individual owning the property is pretty accurate. I would have phrased it only a little bit differently, in that if the owner of the property is some form of a corporate entity, that there's almost immediately a conflict of interest between, as someone described, the fiduciary duty to the association as a member of the board and the fiduciary duty that an officer of the corporation or any other corporate entity owes to that entity. So my first view would be to say, for just a second, let's put trusts aside, but any other corporate entity, be it corporation, LLC, small business, partnership, agency, whatever term you want to use, should not be allowed to run for a seat on the board. And the only way you can determine that is by determining who is listed as the owner of the property, which goes back to the question of, what do we call it? However we described owner, I can't remember the term.
Property of record.
Owner of record.
Property of record, I'm sorry. At any rate, so that you need to sort of crack that nut open a little bit in order to get to that point. But I would definitely think that in terms of limiting someone's ability to run from the board, you avoid the conflict or the economic incentive, as Keith pointed out, by walling off any sort of corporate interest who is listed as the owner of the property of record. As to trusts, and again, I agree in part with what Keith said about if you read some of the social media, there's a lot of discussion about, the trust issue based upon the current pending litigation, whether someone could be a beneficial trustee or a tertiary trustee or just enjoy the benefits of the trust or something like that. Again, it seems to me that this issue is solvable if you say, as to any trust, the only person who could run is one who is designated as the trustee. Again, there are other parties who may enjoy benefits of being in the Pines, even if they're in the Pines full time. If they are not the trustee, they could not run for the board. And it seems to me that is, again, a solvable problem. The only other thing I would say is, as to the 3-year issue, if you go back and just think about as a general matter, anybody who runs for office, there really are virtually no restrictions other than perhaps citizenship for running for public office. You have to be a resident of the state. You have to be a citizen of the United States. There's maybe some age restrictions, but by and large, there's no real restriction. You could be dumb as a doornail and still run for office. That places the burden on the voters, the opponents, and the candidate him or herself to make the case that they should be elected. I understand the point that people are making about having some sort of time limit. And by the way, I'm not declaring my candidacy for any office, so that's not my point. But I think if the issue is, do you have the experience to hold this seat? That is something that is incumbent upon the voters to inquire about and the candidates themselves to make the case for. And in that case, I don't think you need a time restriction. It might be nice to have one, but I don't know if someone, and again, at the risk, I used to be a lawyer, and I always tell people now when they ask me a question, you get what you pay for. But I would say this, I think it would be tough to justify in a court case how you chose whatever time frame you decide to put in, whether it's 1 year, 2 years, 3 years, or if you distinguish between having a committee seat and not having a committee seat, or any other qualification. The purpose of the election is for the voters to weed out the candidates they think would be, or put in the positive. The purpose of an election and a campaign is that the voters can vote in the person they believe in the majority is best qualified for that office. That's why you do these things. So I would have a lot of problem with a 3-year time limit or any sort of limitation like that. I think that's about as far as I got until we get to the other proposal with the same subject. But let me just say, I think the list that Keith put together with, some nibbling around the edges is really a good one. I mean, hats off for putting that together.
I think Steve, I'd like just to say your characterization of this this issue of residency. I think that was really good. I definitely see what you're saying there. Thank you for that.
Mm-hmm.
Okay, Bob, you've got any comments you want to add to this? You're the only one that hasn't had anything to say yet. I don't know, is Bob able to hear us?
It looks like he's muted.
Yeah, he's muted. Bob, if you can hear us, you're muted. Don't see him. Don't see him unmuting. All right. We've all pretty well expressed our views on this particular topic. There are a couple of different considerations that have come up. One, it relates particularly to bylaws provisions, but then when we get into, as Steve brought up, as we get into, or if we get into issues of entities like corporations or partnerships and trusts, membership. Membership's not really the trust considerations with regard to eligibility to serve on the board. Those can be, I think, impacted by the court, whatever the court comes down with. And I think we would be well to limit our consideration at this point in time to such things as living in the community, or how long you have to live in the community, or how long you have to be an owner with regard to eligibility of board candidacy or board membership, because you kind of have to tie the two together. In order to try to keep going on with this subject through what Keith has here, let's continue on and then come back and kind of summarize where we are on this particular topic. And the next topic, and we've kind of talked, maybe we've touched a little bit on some of this before now, but let's take the next two together. Spouses are not allowed to go back to where you were, the prior screen, Josh. The homeowners HOA resources screen. Okay, there you go. 2 and 3 on there are effectively, or at least one's included in the other. Spouse is not allowed to serve. It also fits in the co-owners not allowed to serve on the board at the same time. I'll just say this and stop at that. I agree with these provisions. I don't think we should have more than one, I'm going to call it property represented, or one person per property represented on the board, and that also would extend to where there a related persons, however you want to describe the related, who own multiple properties. That also comes under the same heading. If, for example, my wife and I own 2 properties in Ocean Pines, and we don't. One could not be, I would not consider one eligible to be a candidate or a board member on the basis of one property, and the other be eligible to be a candidate or serve on the board on the other property. But anyway, I basically agree with these 2 provisions.
Yeah, Jim, it didn't occur to me, but you're right. Spouses doesn't really need to be called out separately. I think 3 covers the whole gambit, right? So yeah. Whether you're related to them or not really shouldn't matter. It's whether or not you're a co-owner. So I agree with that.
Well, except for the fact that you might have the husband titled to own one property and the wife titled to own the same property, and then you have the same problem that Jim is now describing.
Oh,
So,
I got it.
I think you would need to keep you could put them in the same sentence potentially, but I think you do need to address the 2 of them together in some fashion.
That makes sense.
I agree. Another point on that though is, well, I know maybe the co-owners probably would cover it. The extent of the relationship. You could have relationships between individuals who own separate property. Do we want to get into brothers, sisters, or siblings, cousins, grandparents, mothers, fathers, that kind of thing?
Or do you focus more on 2 people that live in the same household, whether it be, brother and sister or roommates, and, in that kind of situation. In the PTA land, we are able to have a spouse on there, but they cannot have only one person, because we also deal with money and stuff. Only one of them can be on the bank account, or have access to signing checks and things like that. So maybe are there some stipulations there? I don't know exactly all of the duties of the board, the directors, and I would assume they have no monetary fiscal responsibilities. But that would be the biggest red flag for me, would be if you do allow spouses or relatives who live, 2 adult people who live in the same household serve as a director at the same time. Where's the transparency there? Like, who would have access to what? Because if there's no accountability about, to to troubleshoot or check and make sure that these two people are not doing something that's not professional or whatever. But probably in our situation, I would probably agree that they should not be serving at the same time. I would just want to make sure that we don't eliminate the other spouse from ever considering running later at another point. You know what I mean? Like at a separate time on their own, if that makes sense.
It would also seem to me, under the co-owners idea, if you had a trust and the trust actually owned more than one property in the Pines, you're in the same situation, right? So you'd have to have some sort of language there that focused the co-owner issue on the entity of the ownership and not on the actual address, right? I would think. So, but I think you're right. I think the spouse issue would have to, spouse or familiar relation, family relationship. I don't know. I don't know how you get there, but it's if we were in a state like California where all spouses are automatically part of the property, it's a little different situation than here in Maryland. So starts getting a little sticky, I think.
Well, I
Okay.
think we have updated our definition of familial relationship as it relates to conflicts of interest in our conflict of interest resolution. We can take a look at that and see.
Yeah,
I think what you're getting at is the familial relationship issue.
Right.
Where does the loyalty lie, with the relationship or with the entity, I guess.
okay. I still see that Bob is still, Josh, can you hear me?
Yes.
Do you know if there's a reason why Bob is muted?
No, but
He's
as
not
the creator of
responding.
this meeting, I can't unmute someone. They can only unmute themselves. I can mute people, but I can't unmute people.
Yeah, well, he either doesn't hear us or doesn't have comments that he wants to make. I just don't want to be I don't want to be bypassing Bob's opportunity. That's why I'm.
As a former reporter, no comment is always a good idea.
Okay. All right. In the interest of kind of trying to keep going here, let's go down to the next one. Excuse me. Someone previously removed from the board, not allowed to serve again. I, in general, don't disagree with that. There may be reasons to not really seriously consider that, but it kind of depends on why they were removed. I'm a little reluctant to make a blanket statement on that. But anyway, who else has some kind of comment on that?
So in my mind, so removed from the board, it would be officially removed. In other words, a referendum from the people or removed by a vote of the other board members. And in my mind, because these are so rare that this happens, if it did happen, I would just have to assume it was something extremely serious. If the community got together a referendum to remove a board member, that would have to be something really, really egregious, right? And I would like to believe the same thing if fellow board members got together to vote somebody out, that it would be something relatively egregious. So that was kind of my thinking behind that. Obviously, we would need wording to that effect. Someone previously removed from the board by, either a vote of the people or a vote of the fellow board members, something to qualify that. And certainly this would not, in my mind, include people who resign, because I think there's all sorts of situations under which you could resign from the board that would not, in my mind, disqualify you for running again. So that's what I was thinking initially when I wrote that.
And I understand that. I agree with the comment. Any other comments on this particular one?
Well, just to say that you never will have something that completely avoids the possibility of being sued for any particular reason. That's the first thing. The second thing is within homeowners associations and generally corporations speaking writ large, there's a certain deference granted to the decisions made by that association. So I think the way Keith phrased it just now is at least defensible. Let's put it that way. You're not talking about people who resign for whatever reason. You're not talking about people who resign, and you're talking about people who are removed where the reason for the removal is serious enough that it triggers that very action. I could see where someone would be upset because they were removed 5 years ago and they, atoned for their sins and they want to run again. But at some point, you got to draw the line and say, no, we're not going to take that chance. Whether or not that person then, goes off to the local circuit court, there's no guarantee when he or she wouldn't do it anyway. But it's a defensible position, to be sure.
Okay, any further comments? All right, let's go on to the next one. Convicted felons not allowed to serve. Number 5. Anyone have any comments on that? Okay, I'll make my comment. I have some difficulty. Among other things, what's a felony? I think you can find variation depending on what jurisdiction you're in. Somebody from out of state moves here. For example, we came here from Pennsylvania. I'm not going to try to point at any particular criminal offenses, but what's the possibility of what something categorized as a felony in Pennsylvania is really a misdemeanor in Maryland, and in Maryland there are misdemeanors that are more severe than felonies in Pennsylvania. I'm not saying that's the case. I'm just saying that I am uncomfortable with this use of the term felony without some kind of a description of what kind of severity of conviction we're talking about. What kind of what was the felony? I don't necessarily mean you have to identify specific felonies, but what was the nature of the offense that the individual was convicted of? And the other, I'm also concerned a little about okay, once something happens, you're branded with that forever. I'm uncomfortable with that kind of thinking. Those are my comments. Let's put it that way.
Well, there's a couple of ways to skin the cat, I guess. One would be, you could say, convicted within the last 10 years. That to some degree reduces or eliminates the branding issue, Jim. The other possibility is, you're convicted of a crime in the state of Maryland, which would be classified as a felony. I mean, we operate under the laws of the state of Maryland. I don't know. There probably are some holes between what is a misdemeanor in one state and a felony in another. I think as a general rule, what we consider to be a serious crime, therefore it's a felony, is probably identified in almost every other state as a felony as well. It's not to say it's a perfect one-for-one match, but again, you could just say convicted of a crime in the state of Maryland, which is which is classified as a felony. I'm trying to recall. My recollection is there are certain crimes which are classified as misdemeanors, which could, in theory, carry a jail sentence of over a year, for argument's sake. Most people assume misdemeanors are 1 year or less jail time. I think I'm right. It's been a long time since I looked at the criminal code, but I think I'm right about that. And again, to some degree, the association is granted, there's a level of deference granted to the association for making these sort of qualifications or these decisions in determining who should serve on the board. I'm not sure, correct me if I'm wrong, Jim. I mean, I'm not sure I'm hearing you say we should strike number 5 entirely. You're maybe I'm wrong, but it sounds like you just want the language to be cleared up a little bit.
Kind of half and half. Among other things, as I said, I do have some problems with some of these items as we go down the list, and I would like to see us not be putting into the bylaws, into our governing documents, qualifications or material of any kind that because of something having happened, now we're going to revisit issues and introduce a long list of things that we've got along with for many years not having. I have difficulty expressing it any other way. We now, and I guess it's in Maine because of litigation that's going on, we've got a whole long list of stuff. That's maybe an exaggeration. We have an extensive consideration of items that we've really never considered before. And I just hope that we want us to make sure we're pursuing things that are going to have a meaningful difference in the association. Now, I agree, and I'm not going to try to get into any details because they're not relevant really what we're talking about right now. There are things that have come up in the last several months that I really never considered were being thought of differently than what I personally would have approached if I was in the position of having to do something. And again, I'm a little surprised by some of the things that have happened in the past that merit consideration. Let's put it that way. But a concern I have is that we don't be putting into a lot of detail in this in our governing documents that is just taking up room. You know, do I want to make sure that we have people of integrity serving on the board of directors and committees for that matter as well? But yeah, I certainly am. Let's put it that way.
So if I could just interject something here, I think what Steve said earlier about the fact that it's up to the voters to determine who they want to serve. Maybe a consideration is that disclosure of a felony conviction may be required on the application, just like it is on a job application. The Ocean Pines job application requires that disclosure and disclosure of the nature of the offense. And then it can be put in the hands of the voters to decide, is this offense one that, we, object to, that it's an egregious offense, or is it, some kind of a state that has minor things that they convict people for. I don't know. Just saying. I hear what you're saying, Jim. I think we don't want to bog ourselves down with a lot of administrative minutia. But on the other hand, we want to make sure that we don't find ourselves in the middle of an election saying, wait a minute, this person should not be a candidate for whatever reason.
Yeah, you made a good point about the application of a candidate. There is an application form, and one of the things that could have been mentioned and wasn't back in the search committee. There is in fact a resolution M09 that deals with the search process, and virtually anything that affects the search committee in a bylaws change is somehow going to affect that resolution. And among other things, there's been some discussion about it's come up in the litigation itself about an entry on there about documentation regarding ownership and OPA records, putting something like information on, or an entry on the application that would basically require some form of entry of information like felony conviction, just to use that term, or other issues that may bring to bear the integrity of that's my term, of the potential candidate. How you would phrase all of that to put it on the application form, which is starting to squeeze a lot of material on one page already, is another question. But I think that's a point that to keep in mind, is requirements can be put in resolutions that expect to be followed. In fact, I think without me digging out, opening up the bylaws, the bylaws do say that a candidate has to apply using the form that's provided. It doesn't refer to the specific resolution, but the form is in the resolution. So there's already a requirement for the applicant to document necessary information, and then this kind of thing can, one way or another, be put in that form.
Yeah, and if you look at what Frank Daly wrote, his recommendations, that references information required to be provided as well.
Yeah.
And so I think not all of this has to go into a bylaw. But I think your comments and the thoughts that you all are expressing are valuable, and certainly bear consideration by the board if you feel it should go into a resolution versus into a bylaw change itself.
The only thing I would say is I think Jim is correct. And Colette as well. You could do this through the form. The only concern that I would have is, as either the elections committee or the search committee changes, is the risk that the form would change. So you would have to make sure that the sort of information you're seeking is always included each time, no matter how much the membership of the appropriate committee has changed. That would be the only. You'd have to specify certain things to be included in any form that is used when a candidate, when someone applies to be a candidate.
The form we're talking about is an attachment to Resolution M09, and it is the form that has to be used from one election to the other, unless and until the form is changed by board resolution.
Right. Yeah. So you would have to have the board change the form to accomplish what you're seeking to accomplish here. But that's true. Okay.
That's correct. Yes.
Yeah.
So if the idea is that the voters are the ones responsible for vetting the candidate with respect to issues like this, is the contents of these forms made public?
There's no requirement to do so. That's a side consideration. It's not one that's necessarily come up, but the resolution, and I should know this by memory, but don't. I believe the resolution says that there's not supposed to be any disclosure of candidate application, that a candidate who has applied to be a candidate during the application process. And there's never been any discussion about disclosing the forms themselves. As a matter of fact, the form itself really, in my opinion, again, I want to qualify this, my opinion, is an association record and should be accessible. But there's been resistance to disclosing who's applied for candidacy, and there's never been any discussion that I am aware of disclosing the application form of those who have applied.
So I can understand not disclosing applications unless you've been determined to be eligible and you become an actual candidate. I can see where there would be some people that might apply and they don't pass the initial screening and not disclosing that information. But it seems to me once you become a formal candidate for the board, that information should be made available to the public, especially if we're going to say that being a convicted felon does not disqualify you from service, but it is something that we want to know about. Well, who's we? Who is it? Who is we that wants to know about it? Is it the voting community who is going to, as Steve said, make these decisions and ferret out this information? Or is it the elections committee? Is it the search committee? Who needs to know that information? Because if the voters don't need to know it, then I don't think these other people need to know it either.
So, Jim, I reviewed the resolution on elections, and there's nothing in that resolution that says that the candidate names or information is confidential. I think that's been the practice of the committee, the search committee, and the elections committee to keep that information confidential. But, my skimming through this, I don't find that.
I expect that that's correct. I have no recollection of there being any prohibition on that kind of disclosure.
Yeah, and I think Keith's points are well taken. What do the voters deserve to know?
All right, I'm trying to be a little bit sensitive here to the fact that Keith has a hard shutdown in another 15 minutes. So
my quick question is about this before we move on is then when people apply for committees at every board meeting where the appointment is made official, the application is right there and included in the board package of information. So why would we not have eligible candidates being able to share, at the elections committee or whatever, sharing a application for an actually approved candidate for the election then, or something? Because that's kind of contradictory to me in one sense, that for a committee, you're going to publicize, everything that I answered on the committee application just to be approved to be on the committee. And yet we're not going to share maybe some important information that was on an actual director application, but we don't share that.
Yeah, and I think just to build upon that, Laura, the homeowners survey identified one of their biggest concerns to be transparency. No, I think you raised some good points about transparency there as well.
And I agree, there are different levels of felons. I mean, you would want to know, and actually, I think they're supposed to disclose it too. But if you had a sex offender who decided to run for a director, they shouldn't be participating at any of the events that have the kids, right? Because they shouldn't be. They've been told by the court that they can't. So how would we know if they're breaking their policy there or not? Or that if we choose as voters to actually elect a person in who has that kind of charge on them. So there's still more, I think, that could be discussed about all of that and how we find that information, how we use that information, etc. So that's just my thought on that.
Okay, on this particular item, do we have anything more we want to talk about? What I used to kind of a summary or follow-up comment. There are a number of there are items that can be put, I believe, in the M09 resolution, and I don't. If we were to talk about specifically disclosing the applications, let me get myself focused solely on that. I don't know that would need to be a bylaws provision, but it could be put into effect in the M09, which again is generally a search process resolution, not just a search committee resolution. That upon release of the names to the elections committee, the applications of those eligible candidates is released for publication. Not trying to specify right now what we mean by publication, but I think that could be put in that resolution. I don't see where it has to be in the bylaws. Let me just say it that way.
Jim,
yeah, go ahead. Go ahead.
It could even be just a note on the form itself. By filling out this form and applying for this process, and you're signing here that all this information is true, should you be selected as a candidate for the board, this information will be publicly available. And it's just a disclosure to the candidate that, maybe for some reason there's something on there they don't want to be made public, and maybe they choose not to run for the board in the first place. So it seems like it could be covered just with a disclosure on the form itself.
It definitely, I think, would have to be stated on the form that it's going to be released. That's a very good point. There is a what is becoming a somewhat lengthy block on the form that the applicant does have to sign regarding various aspects of being a candidate, but that if we're going to disclose those applications, I think it's quite necessary that there would have to be that kind of a notification to the applicant that when he or she signs it, is acknowledging that that's going to happen. All right. The next item is someone in litigation with community not allowed to serve. Again, comments from anybody who cares to comment on it?
Well, I guess I would just make the observation, and I can't think of an example offhand, but it does seem to me that there's a possibility that you could have someone running for the board who is engaged in litigation against the association for lack of a better term, sort of pedestrian reasons. I'm not quite sure how to phrase it, but for argument's sake, if there is an issue relating to whether or not the assessments have been paid, or there's a disagreement as to whatever decisions are made vis-a-vis the quality of their upkeep of their lawns or their yard or something like that, or whether or not they could get a bigger, those sort of issues I could see potentially you could end up in court, but I don't know that that necessarily disqualifies somebody from serving on the board. And tied to that, to some degree, is if you have a disagreement, just trying to think of something maybe with one of the employees of the association. Well, the association almost certainly would be dragged into that litigation, but I don't know that that necessarily disqualifies somebody from serving on the board. I am, particularly in light of the pending litigation, sensitive to the point that Colette has made, which is if you're suing the board and you're basically saying the board has done me this great injury, but I still want to be on the board. There's, if nothing else, a level of inconsistency. But it does seem to me that there are at least some potential for different forms of litigation, which may not, perhaps should not exclude somebody from running from the board.
Okay, well, let me just make a comment on the in litigation, meaning current litigation with, and when it says community, I'm going to read that to be association. I don't remember why. It's been several years now. I stumbled across a Maryland case that involved a condominium association, and it involved a dispute over damage to a condominium unit of a board member. And there was a dispute between the board member and the board member had initiated litigation. And there was in addition to the litigation itself, there was the side issue in litigation as to what information that board member was entitled to regarding his litigation with the condominium board or the condominium association. And the issue of attorney-client privilege was very much at the forefront. And the decision there effectively barred him from any board meeting consideration of his litigation. There were some records that he was entitled to see that had to do with billing of the attorneys handling that litigation, handling the litigation with regard to his property damage. But you have a very serious attorney-client privilege issue and fiduciary issue, if I can put it that way, of someone who's seeking to come onto the board. That's really complicated. Not really, it will complicate matters if that individual is on the board. I don't have any particular disagreement with this particular item. I mean, there may be more to consider than what we have, but I personally don't disagree with the item in general. Let's put it that way. All right. I'm interested in making sure we try to summarize where we're at on this before Keith has to leave. Long-term rentals with proxy vote may be allowed to serve. We don't have that situation now, and I don't know that we need to really consider it.
I agree. I think that's a larger issue that's related, but probably needs a separate discussion.
Okay.
Yep.
Next one. Okay, that's the very next page. Josh, if you can scroll down to the next page. Okay, here's where we get some kind of a certification process or some means of establishing that this person has some idea of what they're going to do or are doing, expected to do as a homeowners association director. Okay, what comments do we have? And again, let's we're coming up on Keith's time that he has to leave. Okay, let's, again, Keith is going to have to leave here in a couple of minutes. And I did not come into this particular item other than for us to discuss it. And we have done that. And I don't think we're at a point now where we can start putting together, we certainly can't right now in the time we have be putting together specific proposals. Again, I'm at a situation similar to the search committee. I think we need to be exchanging our own ideas, even proposed, if not exact wording of bylaws proposals, at least a reasonably complete concept of what we would expect to be in a proposal, and in those areas where we have some kind of disagreement, be able to identify, not disagreement, a different direction that that we may go in a particular item that is not disagreement or not full agreement. I think we need to be able to do that and be ready to get down to more serious discussion of proposals, if we have proposals in these items. And I want to very quickly, while we still have Keith with us, we have not gone on to consider the what I'll call Frank Daly proposals and what we think about them. Colette, the committee can take that as something to comment on and respond to Frank or respond to the board, or wait for it actually to get to the board and the board decide where it wants to go, and or refer something to us for us to consider as well.
Jim, may I
Sure, go ahead.
a suggestion? And this is somewhat dependent upon Keith agreeing, but in my mind, I see Keith's research as being helpful to help try to address Daly's proposal. And what I would propose, if everyone is okay with this, is if Keith has time, I'd be happy to meet with him and see if we can put together a discussion draft that tries to cover the waterfront, and then a separate list of other issues that either we don't feel we can comment on, we're waiting to hear from the board, or that requires some other action, such as dealing with the form that candidates would fill out or something like that. Because there are, I having read through Daly's comments and Doug Parks and the one suggestion from Amy Peck, it seems to me that there's a lot of commonality, although they have to be done differently. They have to be addressed somewhat differently. And there's, I mean, I can tell you for one thing, is the reference Daly has to Black's Law Dictionary is no help at all. There's nothing in Black's Law Dictionary that addresses what he's trying to address. That would be my suggestion, if that's agreeable.
Is the suggestion that you would be, the two of you would put something together to come back to this committee with, and we would then review it and send it on to the board? Is that the suggestion?
I certainly am not trying to speak for Keith, but my suggestion would be if we can put something together and circulate it to the committee as an email attachment of some type, and either we can discuss it at the next meeting, or the committee could just take a pass and kick it onto the board or something like that. That might work.
I'm up for that.
Keith, I didn't hear that. Say it again, please.
I'm up for that.
Okay, well, let's go with that. Well, I'm sorry, Laura and Bob. Any comments on that? Bob, I see you're
Am I back on or not?
You're back on.
I signed off, tried again. Today has not been a good day with the computer. But yeah, I think Keith's done a great job in the research, and if they get together, I think they can come up with something that we can work with and speed up the process.
Laura?
Yep. That's fine.
Okay, all right, well, let's go with that, Steve and Keith.
Okay.
And Keith, I guess you're about ready to bail out on us now.
Yeah, I gotta go. Steve, I'll get with you and we'll figure out a path forward. And I think we can easily put something together for consideration.
All right, I'll shoot you an email after this meeting. We can just discuss how to get together after that.
Okay, thank
So,
you. I gotta go.
Steve, as an FYI, Frank Daly is in Florida until sometime in January. His daughter is having her first child, and he and his wife are there for that. So it's going to have to be virtual, which is
I didn't see him at the golf course the other day, so I figured.
okay.
Okay. All right. With that, we're ready to move on to our next item on the agenda, and that's the associate member options talking points for the January meeting. That in tentative, I put in, there's at least, it's any meeting on this topic is tentative, let's put it that way. I circulated some proposed talking points, which I'm looking for here. Are there any comments on that?
Yeah, Jim, I certainly have no objection to option A, permitting associate members to participate in committees. I think that's in part might be a little offset by Colette's earlier comment about the limited number of vacancies on the committees taken as a whole. But if an associate member wanted to try to get on a committee, I guess that would be okay. I guess it's even possible that you could set aside a seat or two on each committee for an associate member to serve. I don't know,
Yeah, if I could interject, Steve, the board has talked about this, the Strategic Planning Committee has talked about this, and there are people on these committees who are property owners who feel very strongly that they do not want to be represented by an associate member. So an option you might consider is we can do mini surveys, homeowner member surveys, to kind of get the will of the people on this. But, that really hands over the thought of these people who are opposed to it is that it hands over to a renter authority that they would not want to yield. And they think it would, it would be murky, in which situations would the property owner allow that and which wouldn't, that it would just become too complicated. So just an FYI, those are some of the thoughts that have been kicked around.
Well, go ahead.
Go ahead. Well, no, right. I understand that. It seems to me that it's sort of a pull and a tug between that issue and the issue of associate members or renters, whatever term you want to use, wanting to make a contribution to the community. So I don't know how big a problem this is. It may be that there's virtually no associate members that want to get involved in this sort of stuff. I would, I guess what I'm saying is I have a little bit less of a problem with A, among the options, allowing them to participate or serve on a committee than I do with the others. I'm certainly not suggesting we should grant them any additional opportunities. I'm not comfortable with the idea of them waving a proxy in the air saying they should be allowed to do something, that sort of thing. Candidly, for me, this is a matter of first impression. I mean, I've never really thought about it one way or the other, but I guess I certainly understand the point. On the other hand, there are people who feel they want to make a contribution. And I don't know where you draw the line, but I understand the point.
Well, there is a line to be drawn, Steve, and that is that the advisory committees serve the board and have input directly to the board, and the board is the governing body. So
Right.
this is service that is in service of governance. There are a lot of other types of service in the community and service opportunities that are available to associate members, whoever. But I think that when it comes to that is a meaningful line that might be drawn, and for just as one person's thought on this.
Okay, I want to kind of back up a little bit here and reiterate some background. It's the very first sentence that you see there at the under the word background. During the executive council meeting, May 26th, etc. Comments were made about perhaps associate members becoming committee members. I don't remember who made that comment initially, but there was general agreement or no expressed disagreement with that being something to consider. And I agreed. Okay, it came up here at the executive council. You folks are all chairs of the committees. I will put this on our list of topics to consider as this came up during my part of the discussion of what this committee was doing, which is a standard part of the executive council meeting. I don't remember who made the initial suggestion. That person may not be on a committee chair now and may not have been there last night. But I agreed at that time, okay, I'll take it to the Bylaws and Resolutions Committee for consideration. Now, what we have here under discussion, under our talking points, is how we progressed in our discussion. We progressed from the consideration simply of the associate member being able to come onto a committee as a committee member. And it did progress to a more expansive consideration, at least in part as a consequence of recognizing some of the practical difficulties of having perhaps an associate member of a property becoming a committee member, but have opinions of what that committee should be doing, what its agenda should be, its agenda items, its position should be in regards to recommendations to the board and so on, that would be in variance with the actual property owner. And how do you confront that? Well, then maybe we should really extend our discussion to an overall consideration of associate members stepping into the position of members. That's how we got to that second, much more expansive step. And that's why it's in this talking points, because that's pretty much the way we left it off. Now, let me go back to last night. There is no question. The informal comments, let me put it that way, that at the board level, there will be significant resistance to go any further than committee membership. And even that is a step perhaps too far. That's the simple fact. As far as I'm concerned, coming out of that meeting last night, and I'm going to refer to informal comment that was made, not necessarily discussion comment at the committee, at the executive council. Now, the one person who did express this conflict of interests kind of thing, a property owner had not at all satisfied or wanting an associate member who was a renter long-term for whatever length of time, sitting on a committee in lieu of a actual member, and that was the ARC committee. The chairman of the ARC committee is the one that was most most, not I want to say outspoken, made the most relevant comment. And it's understandable because of all of the committees, his committee is one that in fact votes virtually any action that it takes. And it's a very independent vote on what they are considering. And it is truly a matter of concern as to where the decision-making votes are coming from, the person or property, the representation of the property. I fully understand that. But let me kind of get that off of my soapbox. And there were some comments made last night about associate members that I certainly didn't agree with. Let me put it that way and leave it at that. There's not going to be video of the meeting. There'll only be at some point in time, a year, 6 months from now, there'll be minutes of the meeting. I don't know what they're going to say. At any rate, that I'm just putting that in background. Certainly, we still have 4 of us on the committee here. We can you know, I don't like proceeding without a full committee on some of these things. This is one that I can set that aside. We can scrap this entirely. We can delete B, the expanded option, and go only with the original expressed interest in can an associate member become a member of a committee. And quite frankly, after last night, I'm not so sure how solid that consideration should have been given 6 months ago. At any rate, I'll offer this up for further discussion.
If the committees are full, why are we even reconsidering it? I thought the intent was we couldn't find enough committee members, and
again was my understanding of the original expression in May. It was help us recruit members to the committees.
And the other side of it is you have 8,000 homes. It's hard to believe if you add up the committees, you can't find 30 people that are willing to sit on committees that are property owners.
There is no question, and this goes back to comments made by Colette earlier. There's no question that we're at kind of a high point in committee participation and committee opportunity to influence the governance of the association. That hadn't been always the case. You go back 2, 3, 4 years ago, it's not, I don't care to get into a discussion of the whys. I have my own personal view of it. And that my personal view is not necessarily the best, the right, or necessary to discuss. But compared to maybe not 2, but 3, 4, 5 years ago, we are at a high point now of association committees participation and people participating on the committees. And how is that going to be a sustainable thing? I don't know. Hopefully it is. Later this year, we're going to find out on this committee. At any rate, is this item? Should I have said, well, it's a nice idea, but I don't think it's ever going to go anywhere. So thank you for your input, and this committee never ever see it. Maybe I should have done that. Been a little bit more future perspective as what may in fact be ahead. I personally have although it's in the talking points, and I'm perfectly willing to take it to the board in a talking points submittal to our liaison. The B item, that's that's never been a very likely approach, but be that as it may, that's where we have discussed this item, and we can make a complete change. We can say, well, after considering all this, in particular, after considering me, I haven't made a report of the executive council meeting of any kind. It did, it's less than 24 hours ago now, and I haven't taken the time to try to send any information out regarding events at the meeting, and I would have had to consider this topic for sure when I did, and I probably should document it in some form and an email to everyone. The events of the executive council meeting last night, including this topic. But we can scrap this item, or we can go move forward in a modified version. Let's put it that way.
Can't we recommend that we will revisit this at a later time, considering, as I agree with Bob, that, when we originally took this on, when you presented it, shared it, it was because we thought we were trying to figure out ways to get participants, to help with the committees. But if we are at right now a point where many or most of them are full, could this be tabled for a later time? Versus not totally discussing it or whatever, but it at least lets the board know that we've looked at it, that we've, but at this time we don't feel that it is something that we need to make a priority with us. We've got all these other, I think, more pressing discussions to take on instead of this one at the moment.
Well,
so, Jim, from the point of view of a director, I kind of agree with Laura that at this point in time, it's not a priority, but it should not go off your radar because it is a policy discussion that deserves to be had and deserves to receive the thoughts of your committee.
Well, as a practical matter, any action on this would require a bylaws amendments. So any tabling means we're tabling any consideration of it as a bylaw amendment, and that kind of an action means tabling it off into the distant future somewhere.
Do we have?
Good point.
I'm not disagreeing with anything. I'm just making that as a comment. Tabling it means it's going to disappear until some unknown future date.
Right. But do we have a clause in place that if we can't fill that super important, opening that might be created by our long-term people here, that they can remain in that position until it is filled, or
no?
Or are you really looking to be done?
Well, as a strict reading of the bylaws say that you have to be a member who is eligible to vote. Well, that eligible vote is in reference in particular to the payment of assessments, not suspended vote by the board of directors. However, an associate member has no vote. So they are in fact not eligible to vote, and in that respect, they can't possibly be a committee member. You're stuck with the bylaws provision. I realize there's kind of an apples and oranges eligible to vote consideration there. By definition, an associate member cannot vote, so they have no right to vote. The bylaws provision is eligible vote related to the payment of assessments and suspension by the board members. That's apples and oranges, but it's still there. You can't vote. You can't be on a committee.
Right.
Okay, again, again, this comes all the way back to, not all the way back, this comes back to events at the Executive Council. If we're going to decide not to pursue this at this time, and regardless of what at this time, when there is a time for not considering that, if we are deleting this, it does have, right or wrong, misunderstanding, whatever, its origin at the Executive Council. I can, if we feel we are not going to pursue this, I can do one of two things. I can send an email to Larry Perrone as the president of the association and the convening officer of the Executive Council, that in my comments about this going to the board for consideration, the Bylaws and Resolutions Committee after reconsideration is withdrawing that from our considerations and will not pursue it further, or some description of that manner. Or I can send it to each committee member referencing the meeting last night, and I think maybe one committee was not there, all others were, and say the same thing with a copy to there were 4 board members last night, at least, to Larry Perrone and Colette. I can do either one, or ask that we consider, or ask our liaison that we consider onward with what we got in front of us.
What you have in front of you, isn't that something, Colette, you could take to the board and see if they're interested in pursuing it? And if not, then it's had its opportunity.
So by that you mean the position paper that you have here?
Yeah, with the
Draft
options.
talking points?
Yeah,
Yeah,
I think,
yeah, let's do that. And let the board decide if they want to pursue it. I think the 4 options kind of cover the gamut.
yeah.
And then you guys can go on to other matters that the board has identified as being more pressing from their point of view. And then if they want you to prioritize this, they can tell you.
Yeah, because
Okay, but I fully agree with that approach. Any other comments? All right, we're now running into close to 3:30. I think we need to wrap it up. The last item on the agenda is to actually begin working on the individual proposals, of which we have several drafts now in our document. What Josh has just put up here. I don't think we want to start on that right now, and we're going to have to make sure we move fairly quickly on when we get back to the search committee and the effort that Steve and Keith are going to be working on. So at this point, I think we've gotten as far as we really need to go on this meeting. I think we've had a pretty good meeting with a lot of exchange of information and ideas, and there comes a point in time when at least I get kind of worn down a little bit in the thinking process, but not necessarily advancing anything. So we need to schedule a next meeting. And my suggestion is we look at January 7th, I believe it is. Same time, same place. 7th, I believe, is Friday of the first week of the year.
Fine by me.
works.
Works for me.
Okay. Josh, let's go ahead with that. As far as a link, I will.
You got it.
I can send an email out to Keith a little later, just tell him put that on his schedule. Hopefully it doesn't conflict with anything that he has. If it does, we'll just have to consider what our options are. and go from there. Okay, anything else we need to talk about? The concerns we have going forward. We got a lot to do here. I still have a lot to do. Let's put it that way. We do have drafts to consider. Colette, I don't know if you've had a chance to see it, but I sent you a message about one of the items on the status dealing with the art committee, or not the, with the art committee, not the committee itself, but the board relationship to the committee. It's that section 5.13H.
Yes, I saw that. And I didn't read it fully.
Okay, it's something I wanted you to consider independent of consideration at this meeting. That's all.
Okay, so I will respond to this email after I've had a chance to read it and think it over. Okay.
Okay, it has to do with the status and what to proceed for, how to proceed forward with regard to the situation that we have right now.
Okay.
Okay. Any further comments, questions, so forth that we have? All right, folks, the holidays are coming up and we may be exchanging emails between now and then. But
I'm not ready.
have a happy Merry Christmas and a Happy New Year. Hope to see you all good health after the new year.
All right, we'll see you next year.
Next year.
2022, I never thought of that.
It's next year.
Okay, have a good weekend, guys.
Thank you.
Good
Thank
holiday, everybody.